I want to first start off by thanking you for the opportunity to be of help to the Canadian Centre for Men and Families. It's a great organization providing support to men who are going through the breakup of intimate relationships, and that's a particularly challenging time in your lives. And people sometimes think men are all independent and strong and don't need help, and it's great to have CCMF providing that help. And it's a real honor to have this opportunity to talk to your members or your people that have signed on. And my topics are not, or my topic today is how to pick a good lawyer. It's not going to be applicable only to men. It's going to be applicable to anybody. I hope that anything I say here won't be construed as legal advice. It isn't really legal advice. And I'm really going to try to talk to you from your perspective or the perspective of a prospective client. I'm always struck, you can go find, there's lots of things on the internet about how to find a good lawyer. Here's a directory of lawyers, and they'll say, well, make sure you've got the right kind of lawyer, make sure the lawyer's got the right kind of experience, take a look at the reviews. And you'll often see those kinds of things on a lawyer's website as well, which is all very good, but it always seems to me as somewhat perhaps self-serving, like, the lawyer is not going to tell you, like, I've been practicing 31 years. Am I going to tell you to go and, find some young whippersnapper lawyer who's right out of law school? Well, actually, I'm going to say that here's how you evaluate whether the experience is what's important to you or not. So it just as one funny example. Sometimes, so we'll get into the presentation here. There's not a lot of structure to my talk tonight. I'm going to cover a number of topics. What I'm hoping is that you're going to get something out of what I say. And if you've got questions, if I say something in a way that you didn't understand what I was saying, like, that can happen. Just raise your hand, ask a question. And if something I'm saying is sparking some other further thoughts that you want to know more about, then put up your hand and we're going to try to deal with it. The other thing I'm going to try to do along the way is kind of talk to you about some of the issues that arise in the relationship between lawyers and clients. And that's something that I think is worth thinking about when you're finding a lawyer. So without further ado, I'll move to the next slide here. This is just a reminder that you have the right to retain and instruct counsel in private without delay. And that's Section 10B of the Charter, which arises when you are charged with or detained on a criminal matter. It doesn't apply in the family law context or the civil context. However, there is you do have a right to a lawyer, and oftentimes if you find yourself in over your head, you're representing yourself, and you say to the court, look, I really think I need a lawyer. The court will generally bend over backwards to give you that opportunity to get a lawyer. And that's because the right to a lawyer is part of kind of fundamental justice rights that people have and that the courts want to have, because our court system is designed around this notion that the judge makes a decision based on two sides putting their best case forward, or each party putting their best case forward and making a decision. And if somebody who's self-represented doesn't know how to put their best case forward, then we're not going to have as good a result. So the courts will generally bend over backwards to give you the opportunity to get counsel. So let's go to the how to pick the right lawyer. And I think it's you have to have an idea of, well, what is it that a lawyer does? A lawyer does several things for you. One is advises you as to what the law is in general, and you can get a good idea of what the law is yourself. You can do a lot of internet stuff, but there are nuances in the law. There are laws that are applicable, say in Alberta, that are not applicable in BC or Ontario or the United States. And so you sometimes you'll see stuff on the internet that will make some pronouncement about what the law is on something, and that may not be the case in Alberta. So that can help. The other thing that a lawyer does is gives you some context, or gives you the perspective that the what your case will look like if you're in front of a judge, what the judge is likely to think about your case. And then the lawyer will then represent you in court or in negotiations and advocate for your interests, subject to a number of concerns that we'll talk about as we go. So first thing is know the right goals. If you want to get the right lawyer or a good lawyer, you got to know what your goals are. And you might think that that's kind of obvious, but especially when you're in a highly emotionally charged conflict, it may not be clear what your goals should be. Like, do you want to cause as much economic damage or harm to the person that has really betrayed your trust, your intimacy, and you thought you had a relationship, and now you feel very hurt, betrayed, angry, and you don't care what it's going to cost as long as he or she suffers as a result of what they've done to you. Well, that's a goal. And if that's the goal, I think it's better to be upfront with the lawyer that you're looking for to see whether that's something that the lawyer believes is appropriate in your circumstances. Sometimes it's when it comes to your kids. Do you want to go for full custody of your children, or do you want to go for shared custody, or are you just wanting to have every other weekend, the standard deal? Now, not that I shouldn't say standard deal, that often it's seen as a conventional solution, but the answer to that question isn't always clear. So it may be that you want a lawyer that can help you sort out what your goals should be, and that's part of the advice process. You can also get assistance from somebody else as well, not just a lawyer. You can also go get advice from a counselor or talk it through with close friends or family members and say, what is the right thing, for me, for my kids, for my life right now. So knowing what your goals are is important. And obviously, you want somebody, if you're going to be, you have a family law problem, you would like somebody who's practicing in the family law area. Whether that has to be exclusively their area, I don't know that is that important, but it will come out through the course of the other questions that you have as to whether or not they are going to be suitable for your case. So the second point here is ask the right questions. As I said before, you can find a lawyer, you Google, divorce lawyer in Calgary, or family law lawyer in Calgary, or, whatever your question is, you'll get the names of lawyers without any, restraining order, lawyer for a restraining order, or, whatever, assault charges, or whatever it is. you'll get a list of lawyers, and the ones who are good at marketing will show up high on the list in Google or Bing or whatever it is you use. Whether they're the best lawyer for you, well, they might be good at marketing, but they may not be the best lawyer for you. Um, so thinking about what the right questions to ask is an interesting one. So here's a question. You could say, well, how many years of experience you have? Well, does that really matter? Well, if you've got a young lawyer who really digs in and is really committed to your case, is that a bad thing or a good thing? Well, it's a good thing. If you've got a lawyer who's many years of experience that figures, well, your case is just like every other case of this, so I know exactly what you should be getting and what you and this is what we're going to be fighting for. Well, this is your life. It's not your lawyer's life, and and that may be a situation where years of experience may be getting in the way of being the right lawyer for you. So obviously, you want a lawyer that has some idea of what they're doing, of course. And here's the question to ask is what is your plan, or what strategy should we use to get to the goals that I'm wanting to go and to go after? And you have a discussion with your lawyer about what, or with the prospective lawyer about what they would propose as the plan. Now, you could say, well, I'm going to, I'll go get a consultation with this lawyer and that lawyer, and we'll, I'll get some ideas from here and there, and now you've got a plan, and you can go put that plan in place. But a plan is something, when it comes to legal services, a plan is something that really is peculiar to the lawyer. So if you are, I'm just going to say, I just noticed here, Reagan, that there's some people in the waiting room. Anyways, what I was going to say is the plan is something that is one that's going to make sense for the lawyer as he's working with you, or as she's working with you, in terms of what his view of your goals and your attributes and his view of the case is. And that lawyer's plan is going to work well for that lawyer, and in his or her mind is going to work well with you. And you might have a different plan with a different lawyer that might also work, because it's a different lawyer. So how do you tell the difference? I mean, how do you know whether it's a good plan or a bad plan? Well, it has to be a plan that you're comfortable with. So going back to the initial question, if the lawyer says, oh, well, we can make that person, the other side, pay, and, we'll make them pay for what they've done to you, and this is how we're going to do it. And if it's giving you kind of a weird feeling about this, well, that's probably not a good lawyer for you. So you might want to, again, as the client, it's your case. And if the plan is something that you're thinking, okay, sounds okay, but then, maybe you're not feeling it. So ask some questions, and, maybe, not to say that your plan is going to be better than the lawyer's plan, but at least there should be a discussion about it. Another question to ask is, would you mind if I came and saw how you are in court when you're in court on another case? That might give you an interesting perspective, because the lawyer says, oh, no, I don't think that would be appropriate. Well, why is that? All right. why doesn't the lawyer want you to see them in action in court if that's what they're supposed to be able to do? So I would be leery of any lawyer that said, oh, well, no, I don't want you to, I don't think that would be appropriate. Here's another kind of related question is, uh, um, will you want me in court every time that the case is there? And if the lawyer says, oh, no, you don't, I'll look after everything, you don't need to come to court. And that's all they say, I would have some questions about that as a client. As a client, you have the right to be present in all legal proceedings in which your interests are at stake. Full stop. There is no qualification to that. It's an absolute right. Now, I should maybe qualify that a little bit. The right to be there is subject to behaving yourself. If you are very, very badly behaved, the court can throw you out of the court. But this is a very close to absolute right. Now, the question, though, is you have the right to be there. Do you need to be there? Well, if the matter is just going to be a simple adjournment to another day, and you're having to take a half day off work or a full day off work or come back from the field and show up for just a 5-minute submission to the court, if that, 2-minute discussion, well, no, you don't need to be there. Sometimes, though, for example, in provincial court family proceedings where parenting is at issue, you really do need to plan to be there for every single court hearing, because while you technically don't have to be there on, if you've got a lawyer, the court in provincial court family expects you to be there unless you've got some reason or leave permission of the court not to be there. In the Court of King's Bench, you can say, well, I don't need to be there because my lawyer is there, and that is technically correct. But I can tell you that the judge knows who's in the courtroom, and if the judge sees that you're not there and the other party is, the natural human conclusion that judge is going to draw is, well, that party isn't particularly interested in the outcome of this case. Obviously, that's not a concern if it's just an adjournment or some routine matter. But if the judge is going to be making an important decision regarding your case, I would encourage you to be there. And if a lawyer says, oh, no, you don't need to be there, I'll look after it, I'd be questioning that. I'd say, look, no, I understand I have the right to be there. And, you'd want to be there. Okay. My third point here, this is perhaps a little unusual. I say, consider the team. And the team is more than just the lawyer and the law firm. The team is also the people in your life. Maybe you're seeing a counselor or a psychologist. If you are, involved in a religious community, you're a priest or a imam or minister or somebody associated with your faith is an important part of your team. Your family members that you are close to, your close friends, they can be part of your team. And what does your team do in that respect? Well, they can help you through the process of clarifying your goals, when it comes time to make decisions about your case. The lawyer doesn't, the lawyer gives you options. You have to make the decision in many times during the course of your case. And that's something that you may want to reach out to your team to talk about. Now, the only thing you have to be careful about that is that um, you don't want to be talking with your team necessarily about the legal advice that you received unless you very, very much trust that person to keep that in confidence. So you're dealing with a counselor or a psychologist, they can be trusted to keep matters in confidence. The same thing with a priest or minister. You would expect that they would keep that in confidence. Family members, close family members, like a parent, yeah, they're probably going to keep it confidence. An associate, a friend at the bar, well, maybe that's a little questionable because maybe you don't know what their connections are to the other side. So that's just something to bear in mind. But I think that the challenge that you're facing is not one that you should be facing alone, and you shouldn't be dealing it with just you and your lawyer. The other aspect of team is who's on the lawyer's team. What's your comfort level with the other people in the lawyer's office, and can the lawyer, and this is a little unusual at Fair Legal, we're exploring the integration of counseling services into the delivery of legal services, because so often it's hard to make decisions about your case without considering the consequence, the emotional, psychological aspects of your decision making. So considering your team now, obviously you want your lawyer to be comfortable dealing with members of your team. Some lawyers may not be, they may not like dealing with the other people in your life because they're concerned, as we talked about, the breach of solicitor-client confidence can create a complication in your case. But there are ways to deal with it. And remember, this is your life. This is not some, law school exercise here that says, well, this is a bright line. You can't talk to anybody other than the client. Well, I've always taken a little bit more of a holistic view to that particular issue and say, no, if I need somebody who's part of my support network to know what I'm going through, is the lawyer going to give me a hard time about that? And that's, I think that's an important question. I'm going to go back to the issue about one question earlier. Ask the right questions. Your case may be really, really ugly and messy. And aside from experience or age or gender or anything, if when you're talking about your case, the lawyer flinches, or you ask a question and the lawyer grimaces or is uncomfortable, well, that's probably not the lawyer for you. I had a client ask me in the first interview, he said, so I asked him if there was anything else I should know that he thought might be relevant to his case. And he said, well, I paid somebody to beat up my ex's new partner. Wow, that's a rather surprising kind of question. I didn't blink. I didn't react the way I just did now. What I did is just simply said, well, just so that you know, this is a good time to have a discussion about solicitor-client privilege, which means that anything you tell me is something that is confidential, and I can't disclose that to somebody. But if you tell me that you're going to go harm somebody, and that is something that is, just blowing off steam, and I think that there's a real risk, I may have a duty as a lawyer to notify somebody that for some unknown reason, person X might have to have a concern for their safety. So I have to be very careful about what I disclose, but I may have to take steps to make sure that some harm doesn't come to some third party. But the questions that you can ask some pretty darn difficult questions, and the lawyer should be able to answer any question. And if they can't, if you think they're just making stuff up, well, that's not good either, right? Lawyer doesn't have to know all the answers, because that's humanly just difficult, if not impossible. Some lawyers might tell you that, they know everything, and if you can't get an I don't know from the lawyer, I'd start questioning whether the lawyer actually knows what they're doing, because the one thing about lawyers is can't know everything. So, okay, so going back to consider the team, be the right client. So here's the advice that you get on the internet is when you go see the lawyer, make sure you take your documents with you. Well, duh. You want to take your documents with you, and if you can get them all organized, great. That's even better, I suppose. And if the lawyer says, if you can organize them in this fashion, pay attention and organize them in that fashion, that makes things a lot easier for your case. But I think being the right client is more than just showing up with the right documents. Being the right client means, is this the advice from this lawyer, advice that you are willing to take? Is there something that you can learn from this situation? You're facing a very challenging situation in your life. Are you going to be fighting with your lawyer about what the lawyer is telling you? Being the right client is more than just showing up with the right documents. It's also showing up, being ready to work with your lawyer and provide information, be truthful with your lawyer, because the lawyer needs to know what the truth is. Because the truth is that the lawyer has to deal with the facts as they are. Now, whether the lawyer, maybe under subject to certain obligations with respect to keeping what you say to the lawyer secret, but you can't. You got to have a basis of you have to be able to have an honest discussion with your lawyer about what the facts are. So those are kind of 4 categories of things that I think is how to pick the right lawyer. What qualities do you want to have in a lawyer? This is my self-serving list. Actually, Melanie put this list together for me, so I'll just give credit where credit's due. I think these are important categories of things: trustworthy, analytical, creative, personable, caring. And you'll get that feeling if you want somebody that you're going to be able to relate to, who feels they're going to be on your side on this, and be able to provide solutions, provide you with ideas, help you through the process of getting to the solution that's going to make sense for you. What type of client are you? Can you be the type of client that a law firm wants to represent and work with? And I think that's kind of an interesting way to put that one. This is more than just, again, this is a two-way street. You want to be the lawyer. will want to know that you are accepting their advice. But if the advice that they're giving you doesn't make sense to you, well, then maybe you should be really considering whether this is the lawyer with you. So it's a two-way street here, and sometimes if a lawyer is finding that the client is just not accepting their advice or recommendations at all, at some point the lawyer actually may have a duty to withdraw from representing you, because it's what we call a loss of confidence. And sometimes it can be very difficult. I was in a situation where I was advocating zealously for a client that was very reluctant to follow court orders that were, and ultimately, I had to withdraw as a result of that, because it was becoming increasingly difficult for me to be able to stand up in court and say, despite many different orders and whatnot, and working with the client, I just couldn't get the client to follow the court orders. And I said, well, there's a limit to what I can do, and so I felt that I had to withdraw. So though that's an important issue. Now, kind of a bonus thing. I'm going to go back to I like the ask the right questions issue. So here's another question we can talk about is, well, what are your legal fees going to be? And lawyers, and I just have to tell you that there's an inherent conflict of interest between the lawyer and the client on this issue. And I'm going to go back to that in a minute. But let's just talk about hourly rates, because that's the first question that people often ask. Well, what's your hourly rate? Well, that is kind of a question that the answer is really a reflection of what level of experience, perhaps special training, perhaps demand on the lawyer's time that might be reflected in the lawyer's hourly rate. But the hourly rate doesn't necessarily equate to whether your case is going to be an expensive case or an inexpensive case. When an experienced, expensive lawyer at a high hourly rate can stand up in court and say in one sentence your case, and that totally changes the direction of the case in terms of what the judge was going to do, and then it was clear that that's what the judge was going to do, and then one statement kind of reverses the case, and that is a level of experience that's one of the values of paying a higher hourly rate. Documents may be prepared quicker, they may be more effective, the representation in court may be better. All of those things may result in the case being, the same, maybe even cheaper than somebody who's got a lower hourly rate. So the hourly rate is not the end of the story when it comes to cases that are billed hourly. You can talk to your lawyer about putting a cap on legal fees, or saying, look, this is the only amount of money that I have. What can we do in this, with this budget? And that's a good discussion to have. There is an inherent conflict of interest, obviously, between a lawyer and a client. The lawyer wants to make lots of money, and the client doesn't want to pay so much. And when the problem with time billing is the client, you as a client, you don't know what, how much time something is supposed to take. And you don't know whether the lawyer, you're not there when the lawyer is working. So the lawyer is working, they put a time entry, they send you a bill. How do you know whether that is, uh, that's a fair description of what was done? And that's where it really comes down to trustworthiness. You gotta be able to trust the lawyer, and you can have a discussion about that. What is, how do we know what a reasonable fee is? How do we know whether this is whether when the lawyer says this took an hour of my time to do, whether it really did take an hour? Well, hopefully that's not the case, that the lawyer is putting in the correct number, or at least not inflating the number. Maybe the lawyer worked 2 hours and said, well, I don't think that this should have taken me 2 hours. So, and this is my practice. If I work on something and it's taken me longer than I think it should have, then I will just record it as a shorter time. If the but here's another one that's a little trickier, is when it comes to the conflict between a lawyer and a client, is your goal may be to reach a resolution, and the lawyer's goal may be to increase conflict. Increase conflict means more fees. The case goes on for longer, and all you want to do is resolve it. This goes back to the original question, know your right goals, talk about what the plan is. What people don't realize is that in the course of litigation, sometimes the opposing party will raise some issue, or they'll go on the attack or whatever, and the lawyer has a decision, and the lawyer is going to make a recommendation. And there's a lot of decision that goes into that. Does the lawyer escalate the fight? Does the lawyer give up the fight? Or does the lawyer try to do something else in order to get to a resolution? If the lawyer just doesn't back down on any fight and loses sight of what your goal is of resolution, then the lawyer is just driving up the cost of the litigation to really no good end. So, having a discussion about how you get to a resolution is an important discussion to have with your lawyer. Yeah, so that's that question. Anybody have any questions? Nobody's put up their hand, so I'm just assuming we're going.
I do have Charles. I do have a couple of questions.
Yep.
Couple of questions that have come through to me directly. So, this is the first one. So, how feasible is it to seek an integrated strategy if you have a false domestic violence allegation and charge to fight, in addition to impending divorce process and gaining child access while you deal with the legal battles? Is there a preferred approach with two legal battles? Is it better to get a family lawyer who handles both, or instead finding a criminal lawyer and a family lawyer who can work in an integrated way?
Okay.
Sounds familiar.
Oh, this is a fantastic question. I should have thought of it on my list here. Okay, so, and the reason why it's a good question is I like the way it's worded. The important thing is that the criminal lawyer is sensitive to the impact of their decisions on their client's family law case. So what and here's where there's a this is just so you know, at Fair Legal, I do both criminal defense work, and I do family law, and I do civil law. And part of the reason I got into criminal defense work is because of this problem. what looks like a really good deal from a criminal law perspective can be very bad from a family perspective. So you plead guilty to some offense and you don't get any jail time and it's done and you get a conditional discharge or whatever it is. And you think, well, this is great. I didn't have to go to trial. I don't have to go to jail, but you're done on the family law side because now you've got a criminal conviction. And now with the recent changes to the Divorce Act, the court forms actually require people to actually disclose the existence of criminal law proceedings, and now you're going to have a big difficulty. Well, then the question is, well, what about peace bonds? Because peace bonds are a little lower level. There's no criminal record, but a peace bond requires an acknowledgement that the complainant had a reasonable basis for fear of you. And well, you can see how that can greatly harm your family law case. And I've been in the position of, because I represent both men and women, I've been in a situation where, I've stood up in court that cue the one-line sentence, say, Your Honor, I must remind you that there's a peace bond in this case, and previously you raised this as a concern and you stated that you believed the child. One sentence created a great deal of havoc. Okay, so you got to have a criminal lawyer that is sensitive to the impact on the family law matters. And here's where there's I think sometimes a conflict of interest, because a lot of criminal lawyers will charge a flat fee. And the flat fee from the client's perspective seems like a good idea. You say, okay, well, this has cost me $5,000 or $10,000. Well, at least I know what it's costing, and my liberty is very important to me. So the lawyers say that he's pretty sure that he can get a deal, that I'm not going to have to go to jail and it's going to cost me $10,000. The lawyer's saying, well, I'm taking this case on for $10,000. I don't want to run a trial on this one because I'm not going to be making any money. I'm going to be losing money on it. So I'm going to push the client to settle for something so we don't have to go to trial. See where the problem is? So what sounds like a good deal, a flat fee may not be appropriate in the situation. Now, I recognize that this is a very difficult issue because you may not have the money to go to a trial, and you may have to really, really struggle with, maybe the risk of trial is really high, that there's going to be a conviction if you go to trial. Maybe the outcome of trial is going to be worse. You got to work through that stuff. There's no easy answer to this. Some questions there is no easy answer for. Now, the question is, do you want to have somebody who can do both sides? Well, here's something that interferes with the criminal defense lawyer and the family lawyer workings. The criminal defense lawyer gets the disclosure, but they can't use it in the family law side because it's subject to restrictions that it can only be used for the full answer and defense to the criminal charges. Can't be used elsewhere. Now, if your family lawyer is also your criminal lawyer, well, the family lawyer knows what the charges are, knows what the details are of the allegations, and can use that information to at least counter false allegations that are being made, or exaggerations of the criminal proceedings, or distortions of what the criminal case is about. They can actually use that on the family side. The other thing, hang on. The other thing is that you can take information that you gain on the family law side and use that information to advance your criminal defense case. And I've done that effectively in a number of cases. So I actually think that there's also a concern. I have a concern with that restriction on the use of information in the criminal proceedings. I have a problem with the way the law right now is, that you can't use that for anything other than the criminal defense, because the law also is that it has to be considered in the family law. And so in divorce case, for example, so you have the criminal code, which is a federal statute, and the Divorce Act, which is a federal statute. And the one says the Divorce Act says you have to consider the criminal proceedings, but the criminal law says you can't use that information outside the criminal proceedings. I think that's a problem. I'm waiting for the right case to come along to really challenge it. So, because I think I think that there can be an injustice if the criminal matter is, if that criminal disclosure is not usable in the family law side, because it can result in an injustice on the family side that not only affects the person who's been charged criminally, but it also affects the children. And I think that the rights of the child, according to the UN Declaration on the Rights of the Child, need to be taken into account both by the family law court, but they also need to be taken into account on the criminal court side, where while historically the criminal court has said, this is not our expertise, we're not going to make any decision regarding the children. Well, then you can't withhold the information from being used in the family law side, is what I would say. So, but that's my opinion. I don't know that there's been any law made on it, but that's, and maybe it's changed since the last time I looked, but that's been a long-standing situation. So that's a long answer. Sorry for that, Melanie.
That's okay. We have a couple more questions here. Okay. 10 minutes. So, okay.
Good.
Next question is, I have hired a lawyer who was good in the first 2 or 3 meetings, but then their behavior became normal and they started using delaying tactics and not responding to me. How can I tackle the situation? To whom should I complain about my lawyer, and what is the result of such a complaint? If I've been working with the same lawyer for a long time, what is the impact of making a complaint? And what factors should I consider before deciding to move on to another lawyer? And I mean, I don't think this really matters, but this particular person is on legal aid and is in Ontario, but I don't think that necessarily matters. So.
Well, that's partly knowing who the team member is. I think what you, first off, in order to, if you're going to make a complaint to the Law Society, which is, can be done, you have to recognize that in itself doesn't advance your case. It may deal with a lawyer who really needs to be monitored because you don't know what's going on, right? You know, maybe that lawyer has developed a substance abuse problem and is not paying attention to not just your file, but also other files. So there is a public interest in perhaps having somebody take a look at it, but that doesn't advance your case particularly. If you are going to make a complaint, you want to make sure that that you've documented reasonable attempts and know what the response is. So, you know, you send an email, you don't get a response. You phone, you leave a message, you make a record, you make a note that you've called, you follow up with an email that says, hey, I called and left a message and nobody's called me back. You know, you wait a couple of days, you send another email. You can ask to set up an appointment. You can walk into the office without an appointment and say, hey, you know, I just want an update on my case, what's going on. And that's part of the consider what the lawyer's team is doing. You know, the team, the lawyer's staff members should be able to tell you something about what the case is. They should be able to say, look, we can set up a meeting with the lawyer and we can discuss this. Now, as I said, making a complaint doesn't advance your case. And then the question is, well, why is it that this thing is stalled? And that's the problem that I think is distressing from a client's perspective is, why is the lawyer not doing anything? And you don't really know. So you might want to go and check with another lawyer and, describe the case as best you can and say you don't know what's happened. And it may be that the lawyer doesn't know what to do. And, sometimes really difficult cases, the lawyer doesn't know what to do. And so they kind of avoid dealing with it. I mean, lawyers are human beings as well. And they sometimes are faced with a difficult situation. They don't know what to do, so they do nothing, which is not the right thing to do. I'm not saying but that is, so it may be that a change of lawyer is something that is necessary to do. Maybe that the lawyer is just simply not communicating that, maybe a delay strategy works better. In family law, we often say that there's really two kinds of divorces. There is a legal divorce where the parties are separated, whether they're married or not. When I talk about a legal divorce, I mean you've separated, you've dealt with all the financial matters, you've dealt with the kids, you have resolved all of the issues that are in dispute. That's what I call the legal divorce. You're done. But then there's a thing called the emotional divorce. And, somebody may not be really, really ready to settle or get to that legal divorce. And what we say is if one or both parties is really has not reached the emotional divorce stage, they don't have to reach the emotional stage in order to get the legal divorce. But if they're not there yet, what can result is that the divorce can be much more difficult and expensive and time consuming, because the lawyers can be sitting there working away at it and the case just gets undermined by the clients all the time and it just stalls. The legal aid system may cause may be part of the problem, in the sense that if one party hasn't reached the emotional divorce stage and this thing is just going to be a big fight, there may be caps on the amount of legal aid. In fact, years ago, I practiced in Ontario, and I still remember the last legal aid file I took on a family law case in Ontario was, I put a ton of time into the case, and then they didn't pay me. The hours got capped. The client had been taking unreasonable positions probably, and was taking up a lot of time. Then they weren't going to pay anymore. And now, is it right for the client to just stop working and not say anything? Well, no, that's not the right answer. But, maybe the lawyer might be thinking, we just need to chill out a bit here. Maybe this thing is going to be an easier case if we just wait a few more months on that. Not saying that may be a good plan given your budget and the circumstances, but it's certainly something that should be discussed with the client, and it shouldn't just be, the lawyer unilaterally saying, well, that's what the plan is, and I'm not going to tell anybody, or I'm going to say that's what the plan is if anybody asks me. That's not the right way to approach it. So yeah, it's a difficult situation. You may decide that you want to change a lawyer, but remember, you got to pay and this may be more of a concern. In the legal aid system, you're going to have, you might get away with changing a lawyer once, maybe twice, but then you're going to run into troubles with the legal aid system that they're going to say, wait a second, yeah, maybe there was a problem with one lawyer, but now you got a problem with a second lawyer. Maybe it's the client, not the lawyer, so we're not going to pay anymore. So you got to remember that trying to solve the problem with the lawyer might be a better way to go than just trying to get a new lawyer. The other thing is that when you change lawyers, if you do it too often, it starts to look to the court like you might be the problem and not the lawyer. So again, courts understand this is, sometimes there's a falling out between the lawyer and the client, or whatever, maybe the lawyers change firms or whatever. So the court's not going to concern itself with one, maybe two changes of lawyers. But at some point, I've had cases where the other side changed lawyers 10, 11 times. The judge, they don't say anything, but they know what's going on. They know they're making a reasonable inference that the reason why there's so many changes of lawyers is because the client is not listening to the lawyer's advice and decides that what they're going to do is just change lawyers, or they're changing lawyers as a way to delay the case. Because you'll get, again, going back to that idea of the lawyer, courts want to make sure that people have legal advice, so you can delay by changing lawyers, and the courts will get onto that pretty quick and stop it. The other thing is, when you change lawyers, you got to pay the lawyer to get up to speed on your file. So that's maybe you can get some of that money back from the first lawyer, maybe not, who knows. The other thing is that if you are going to call the Law Society, or you can call the Law Society, and I don't know what the situation is in Ontario, but I think in Alberta, I'm not sure, but there might be a mediation type service, and you say, look, I don't want to complain, but I'm wondering if perhaps you can assist in maybe helping me communicate better with the lawyer. If you said that to the Law Society, they'd be all over it, and they'd be supportive of it. And if they can't get the lawyer to pay attention, then they will institute discipline proceedings against the lawyer. Yeah, and another option, I suppose, would be to if the lawyer is in a law firm, and I've done this when I'm dealing with a lawyer that's not responding to me, is I'll write to the managing partner and say, I've been dealing with so-and-so in your firm and I'm not getting any response. That's when I've done that, I've usually gotten a response within a couple of days. So sometimes even opposing counsel has trouble getting lawyers to respond. And that's how I've dealt with it. Complain to the managing partner, talk to another lawyer and say, look, would you mind calling up this lawyer and just talking to them and say, look, I got to just know what to do about this case. If the lawyer's run out of ideas, the lawyer is, can't do it anymore on legal aid or whatever, that's fine, but you just got to have communication, and maybe another lawyer will help. So those are some suggestions on how to deal with that. Sorry, that's another long answer. there was maybe some help there.
Okay, I'll give you a couple of, I think, can be quick questions,
okay,
quick answers. Okay. Don't take too long on them. So does the lawyer themselves have to give you reason why they are dismissing themselves from the case, or can their secretary tell you they have dismissed themselves from the case?
Ooh. I think they should tell you. I don't know whether they have to tell you. There's what you can do is if you have questions about this kind of thing, that's a question you can actually ask the Law Society as well, and they'll tell you. There in Alberta, we have, and in every province, but in Alberta, we have the Code of Professional Conduct that covers all of these things, and it's a very thick document, and there's lots and lots of things. So I just don't know the question. My gut's telling me, yeah, you should tell your client why you're withdrawing. In fact, I'm pretty sure that's it. Here's the thing: is a lawyer is not allowed to withdraw in certain circumstances. The lawyer needs the court's permission to withdraw if a trial date has been set. So the court needs, if the lawyer needs the court's permission to to withdraw, then somebody needs to know why the lawyer's withdrawing. And of course, the lawyer can't disclose, the lawyer can't say, well, because I think my client's an idiot. No, the lawyer can't say that. But what the lawyer might say is there's been a breakdown in the solicitor-client relationship, which is code for the client's not paying, the client's not accepting my advice, the client is giving me instructions that I can't follow, but the judge isn't being told which of those big categories it is. I think, the more that I think on my feet here, I think really the lawyer does need to tell you which it is. Is it because you're not paying the bill? Is it because you are not following advice, or giving instructions that the lawyer feels that they can't follow for ethical reasons, because that can happen. And the lawyer should be telling you. I think the lawyer just quitting without explanation raises a question as to maybe the lawyer has engaged in misconduct that they're hoping nobody notices. Well, here's the thing, is that the lawyer, I think, has the duty to tell you that as well, so that you can take steps to fix it, because otherwise, how would you know, right? You're relying on your lawyer to have your interests at stake, and that's the case even if your interest is contrary to the lawyer's interest. That's the thing about being a lawyer. We get a lot of privileges as being a lawyer means that we have an obligation, right? We have to put the client's interest before our own. So.
Okay, we're just gonna take one more question, unfortunately. Does the client have the right to any and all communications?
My practice is that the client should receive copies of all correspondence, whether it's incoming or outgoing. And that's a policy that I have. I know that that's not the case for all lawyers. I don't know what the justification is for not doing it. If say a letter comes in and the other side is complaining about something that the lawyer is doing or not doing, and you don't send it to your client, and the client finds it out later, the client is going, oh, well, I know why you didn't want to send it to me, because you're feeling guilty, you're embarrassed by it, and you didn't want me to know. Well, that just makes it worse, right? So just because the other side is making some complaint doesn't mean that it's valid. So why not send it to the client? Better to, it's like you gotta it's like ripping off a Band-Aid once the wound is healed. You're better off doing it quick. So I know that not all lawyers do that, but I think it's the right thing to do. And you could say that part of the question, picking a lawyer, do I get a copy of everything? Now, sometimes, lawyers' staff are busy. Maybe they miss something, it could be inadvertent, that's one thing. But if there's a general view is that, well, you don't get everything because I'm the lawyer and I know better, and you don't really know what this stuff is about anyways, and I don't want to trouble you. I don't think that's a valid reason. One other issue does come up, though, is what if what the lawyer has got is a psychological assessment, and the psychological assessment report says that they are concerned that if the client gets this report, that they are going to cause harm to themselves or somebody else. Well, that puts the lawyer in a really difficult position now, because now they got to say, well, is this the client needs to know what the results of the report is. And I think the lawyer needs to be very careful about that. And sometimes we see that in child protection proceedings, that there's this idea that the clients shouldn't know. And I don't like those kinds of restrictions. So when I get that kind of a restriction, I fight against it, Because, you know, I've got a client right now who's subject to a Mental Health Act community treatment order. I think the client is entitled to know what people are saying about them, you know, period.